synagogues, mosques, but it includes exemptions for essential business, such as drugstore, grocery stores, and so forth. Are these legal choices unconstitutional? Can courts in these cases turn to analogy, as they often do? This usually entails, as you know better than I do, the following conclusion: if favored secular activities are sufficiently similar to the disfavored religious activity, freedom of religion must prevail. If favored secular activities are markedly different, the court should defer to the state legal choices and reject the freedom of religion challenge. Is this a fair solution? Is this a fair method, constitutions-wise? Or can one simply go straight forward, saying with Justice Gorsuch of the SCOTUS that, I quote, even if the Constitution has taken a holiday during the pandemic, it cannot become a sabbatical. Be it as it may, and it will be made clear during this panel, what is certain is, as again Professor Martinez-Terron put it down, that this is a delicate matter in which culture, history, and socially accepted values and ideologies play a crucial role. All the more interesting will then be listening to our speakers. They all are young and very promising scholars. All of them are postdoc fellows coming from different Italian universities. Matteo Giannelli from Florence, Giuseppina Scala from Padova, Valerio from Federico II in Napoli. The discussants are distinguished and well-established scholars. Matej Avbelj is professor of European law at a new university in Ljubljana, Slovenia. He got an LLM at NYU and a PhD at EUI. Stefania Ninatti is a professor of constitutional law at the University of Milano-Bicocca, and has been, besides many projects with esteemed colleagues and some case also friends. She has been an EUI fellow. She has been an Émile Noël fellow at the Jean Monnet Center at NYU in different years. And there's also Andrea Pin, who's a professor of constitutional comparative law at the University of Padova and a senior fellow at the Center for the Study of Law and Religion at Emory University, Atlanta, Georgia. But let me remind you that he has always been a clerk judge at the Italian Constitutional Court for a dear friend, a distinguished scholar, and currently Minister of Justice, Marta Cartabia. We start with speakers. Each speaker and each discussant has 10 minutes available for respectively presentation and comments. And the first to have the floor is Matteo Giannelli from Florence, who will speak on unilateralism and bilateralism in the restriction on worship in Italy during the pandemic, sources and relationship between the state and religious organization. Dr. Giannelli, you have the floor.
Thanks, Professor Bussani. Thanks to the organizer, to Professor Faraguna. And firstly, I want to apologize for my bad English. So then, my contribution intends to carry out an investigation through the legal sources on which the restriction of worship were imposed, with the aim of verifying whether and how the normative management of the pandemic in Italy affected the bilateralism that characterized the relation between the state, the Catholic Church, and the various religious denominations. The main point of reference for my analysis will be the contents of the Prime Minister decrees, the IPCM, and their annexes, And my aim is to verify in the context of Italian ecclesiastical policies the difference in treatment between the Catholic Church, religious with an agreement, and religion without an agreement. The main act will undoubtedly include the annexes to the DPCM of the 17th of May 2020, reproducing the protocols on the resumption on celebration, signed also with the convention that not have seen agreements with the state. In this context, the contribution of the technical and scientific committee should not be underestimated. It is not by chance, in fact, that the criticism from the Italian Bishop Conference contained in a statement of the end of the April 2020 was also addressed to this body. Moreover, some of these considerations may be analyzed in the light of the peculiarities and the possible development of the discipline related to the Green Pass, a discipline that, as is well known, does not apply to the performance of religious services, but is instead autonomously adopted by individual religious denominations for the performance of other activities that take place indoors, for example, catechism. So, the most critical phase in the balancing between freedom of worship and the right to health is the one following the Prime Minister decree of the 26th of April 2020. Following this measure, in fact, an harsh statement by the Italian Bishop Conference was issued, in which it stated, now, after this week of negotiation, that has seen the Italian Bishops' Conference present orientation and protocol with which to address a transitional phase in full compliance with all health regulation, the decrees of Prime Minister passed this evening arbitrarily excludes the possibility of celebrating Mass with people. The Prime Minister offices and the Technical and Scientific Committee are reminded of their duty to distinguish between their responsibility to give precise health indication and that of the Church, which is called to organize the life of Christian community. There is a very significant passage in this statement in which it is said that the Church has accepted with regret and sense of responsibility the restrictions introduced by the government to deal with the health emergency. This is a very important reference because it testifies the fact that the Italian Bishops' Conference has acted by implementing the state's regulatory measure with some form of collaboration. Thereupon, there was a real turning point. After having overcome the so-called phase one of the general lockdown, they need to adopt new control measures during the pandemic, led to the protocol of the May 2020. The one seen by the Italian Bishops' Conference with the Minister of the Interior, and the other with the other confession. Contrary to the initial assumptions, the path chosen by the Minister of the Interior to regulate the resumption of public worship by denomination other than the Catholic was not to adopt a single document valid for all, but rather a series of protocols seen with the representative of one or more religious denomination. The signing of this protocol, 7 protocols, was preceded by an institutional meeting attended by a representative of the various confessions. Professor Consorti just said it. This marked the transition from a bilateral pactional policy to a policy of multilateral consultation in the regulation of the relationship between the state and the religious denomination. The exhaustion of the first phase of the pandemic was accompanied by the reappearance of unsurpassed contrast and fractured lines, in some respect physiological, which time after time may change their formal appearance, but which refer to a dialectical tension that remains substantially unchanged. From this point of view, the reason for the collaboration between the government and some communities in tackling the pandemic, despite some reluctance, seems to be a matter of mature solidarity, in accordance with the constitutional provisions in many respects, Article 2 in particular. This form of collaboration must be framed within the supreme principle of secularism and in particular the essential corollary of the distinction between orders. The experience of the protocols on liturgical and religious service submitted to the signature of the confessional representative has shown us that the contents of parties' commitment were identified correctly after selecting interests framed within the framework reserved for precautionary standards and for the adaptation to worship understood in broad sense. At this juncture, it is important to say that there were also a removal from the model of bilateralism design after the ruling number 52 of 2016 of the Constitutional Court. Then the academic literature, the scholars have posed the problem of considering what kind of collaboration between the states and the confession these protocols point to. Certainly, the drafting of protocols with other religious denominations has shown a tendency to adopt a standard text, like the agreements, to which the parties dialected concerned on the denominational side have made small variations, like said before by Maximilian. In doing this, the protocols has maintained a lighter tone compared to the protocol with the Catholic Church, as regards the mention of regulation of individual aspects of internal life for religious organization. Lastly, doubts remain as how to the provision of the protocol for resumption of worship were actually enforced. It is certainly not a novelty or a rule valid only in this field, but much has depended on the spirit of cooperation and sense of responsibility with which the recipients of the rules have been able to collaborate in achieving the balance that the protocols have sought to delineate. However, the greatest merits of the stress test of the pandemic on the ecclesiastical source of law system lies in the extension of the canon of reciprocal collaboration, which has acquired the scope of a general principle in this field. I will apologize again for my bad English, and I will thank you. I would thank you.
Thank you very much, Dr. Giannelli, also for being full compliant with the time limits. Now the floor is to Dr. Giuseppina Scala, who will talk on legal realism and non-binding recommendations, constitutional protection of religious freedom in Sweden during the pandemic. Dr. Scala, you have the floor.
Thank you, Chair, and thank you, Professor Faraguna, for inviting. And let me say that I don't want to apologize for my English, but maybe for my Swedish English. So, within the COVID pandemic, Sweden represents, as you know, a very distinct case. As you know, newspapers, news at the TV were always talking about Sweden as a very distinct legal order when it comes to adopted measure taken by the government. So when I saw the call for papers sent by Professor Faraguna, I thought maybe I could go further on this and try to understand why this legal system is so distinct. For this reason, I will today present my paper based on 3 steps. First of all, I will give you a very brief sketch on constitutional remarks on this distinct legal order. Second, I will give examples on the peculiarity of this legal order within the issue regarding COVID-19. And as a third step, I will try to trace which is, and of course, which maybe are, the approaches held by the Svenska kyrkan, the Lutheran state church, as well as the ones adopted by the other religious organization. Finally, I will offer you my conclusions, but I think it is the most interesting part of the presentation, trying to answer to 3 questions, just to go a little bit ahead of COVID-19 and don't stuck in the mud in this issue. First, I will try to answer to this question. And this is also something that I got in mind after reading and listening to Professor Turon and his comparative perspective on this. Did the pandemic underline once again the dichotomy of the religious landscape within this legal system? Second question I will try to answer. How can we define the response of the Church of Sweden and the response of the all other religious congregation in Sweden? Can we use the same expression and same terminologies that we have in Italy? Third question, more in general, why did all Swedish faithful respect the non-binding recommendation adopted by governments, and why all Swedish faithful decided to undertake this soft approach? I have to be honest. I had a meeting on Monday in Lund University with a prominent scholar of comparative law. And he said to me, well, Giusy, you cannot use this term soft approach or soft recommendation as the international doctrine use when it comes to Sweden. And I was asking him why. Well, in the legal system and in the legal thinking of the Nordic countries, this expression doesn't exist. So I will use this, but just as a convention. But I would like to underline that this is not part of the legal thinking. As to go to the first step of my research, Sweden belongs, as you know, to what we call the Scandinavian Nordic law or Nordic family of constitutional law. And Sweden, together with Finland, makes up these twins, these legal twins of Scandinavia, which are, of course, linked thanks to legal sources, thanks to the legal thinking, and of course, thanks to this codification they had. From a constitutional point of view, Sweden is very distinct because we have 4 fundamental laws, which of course constitute the constitution as we used to named in Italy. And articles regarding fundamental rights and freedom are, of course, as a sort of list in one of these fundamental law. And in particular, of course, religious freedom is guaranteed. And Article 1 of comma 6 of one of this charter is as follows. Freedom of religion is guaranteed in the sense that it is guaranteed in the public, but also in one's own practice. And moreover, I should also add, and this is something that I add now, but it will be helpful for the conclusions, the King of Sweden should be Lutheran. And this is also an article that is still in force after 20 years from the disestablishment of the Church of Sweden vis-à-vis the state. When it comes to the second step of my research, the peculiarity of this legal order rised, of course, during the pandemic, and it is twofold. From one end, Sweden has had a unique approach to the limit of the virus, and from the other perspective, there is a specificity on the legal framework for the adoption of the limitation and obligations during COVID. 5 are this very distinct approach. First, when it comes to public spaces, primary, lower, secondary schools, nursery, bar, and restaurant, as you know, they were all closed in all member states, a part of Sweden. Second, in Sweden, there is no article on state of emergency or other type of emergency declaration. The Swedish constitution does not provide any article with the reference of this expression, state of emergency, in peacetime. Third, in Sweden, there hasn't been any hard pressure on masks. I was there for 2 weeks and I got the impression that they don't even know what mask is. If you go to the university, you just have the impression that no virus is there. Yes, I have to run up. And fourth, from a medical point of view, Sweden has this kind of mitigation approach. And up to date, there is also no requirement to have a vaccine pass to enter public spaces, which is currently only used for traveling. But this is something that I will just go further. When it comes to the Church of Sweden and to the Lutheran Church, to the other religious organization, they were all online with the governmental decision. So no matter what, they just respect what the government decided. So when it comes to my questions, I would say that, first of all, did the pandemic underline the special treatment for the former state church? Well, my answer is no. I got the impression that for the very first time, when it comes to the consideration of the Lutheran state church and the other religious communities, we had the impression that they were tended to treat it at the same level, even though there is an historical link with this ex-agency of the state. Second, when it comes to the expression collaboration on this COVID pandemic, I wouldn't use the same expression used in Italy. If in Italy we use this mutual collaboration or loyal collaboration, I'm not sure we can use it for the Swedish system. I would prefer using respectful collaboration. And this is the main result of the workshop we had in Oslo last week. All the Swedish, Danish and Norwegian constitutionalists, they were absolutely in line with this expression. Respectful collaboration of what the governments were saying and not mutual. Third, and I will finish, why did all faithful respect the non-binding approach? Well, this is something that it could be, in my opinion, linked to what the Scandinavians call a social trust on state. So the legal expression social trust on state is something that comes, of course, from the history. And on this pragmatic approach on the relationship between the citizenship and the state. And so what is the role of this legal realism coming from the 80s and 90s towards today? Well, this is the approach the citizens have. Therefore, this is the approach that all faithful have vis-à-vis the governmental decisions. And I finish. What about the fracture of the system? I'm thinking on the role of the king. I was a little bit shocking when I was trying to get the translation of the speech of the king during Easter 2020. The king is, of course, Lutheran. When it comes to the representation of the state and when it comes to this speech, I had the impression that the Lutheranism, as a sort of principle of constitutionalism is there. So this is my critique to the system. Every suggestion is welcome.
Thank you very much, Dr. Florence. Now the floor is for Dr. Valerio Dalò from Napoli, who will speak on religious freedom during COVID-19 in courts evaluations. Dr. Dalò, you have the floor.
I thank Professor Mauro Bussani for giving me the floor. I would like to greet and thank Professor Pietro Faraguna and the entire project team for the invitation to participate in the forum. I am very sorry, I really wanted it to be there, but I had some serious problems that prevented me from doing so. As we know, the COVID-19 pandemic has required all states to adopt measures to manage the risk remote or realized arising from the spread of the virus. This was done in order to protect the health of individuals, which is recognized and guaranteed as a fundamental right, as affirmed not only by national constitutions, but also by supranational charters of rights. The measures to combat the pandemic, also inspired by the precautionary principle, have highlighted the problems of balancing health protection with other fundamental rights and freedoms. In this context, religious freedom is also seen its sphere of operation restricted, particularly in its essential dimension of the public exercise of worship. Few measures to have led to the suspension of religious rights or limited the number of participants. If the first of the above-mentioned measures implied a substantial denial of the right, the second one guaranteed, albeit with limitations, the exercise of that right. Therefore, starting from an analysis of the arguments put forward by the national courts of some European and non-European countries, specifically Italy, Germany, France, and United States of America, in assessing the legitimacy of emergency measures, we have intended to examine the central role played by the principles of proportionality and reasonableness in the protection of the right to religious freedom. As for the subject matter of the investigation, we have chosen to focus our attention on German and French legal systems as the expression of a system of relations between the states and religious denominations, the first of a covenant matrix, like the Italian one, the second of a separatist type. The analysis of the jurisprudence of Supreme Court of the United States, however, was inspired by the desire to examine the approach adopted to the issue in question in a legal context outside of the so-called European legal space, and characterized, like the French one, by a model of relations between the states and religious denominations of a separatist type. Examination of the judgments of the national courts of Italy, Germany, France, and United States has shown that the application of the principles of proportionality and reasonableness in assessing the legitimacy of measures limiting the faculty of collective exercise of religions had led to not uniform results. With regard to proportionality, there are differences in the assessment of the adequacy of the measures, the so-called German Verhältnismäßigkeit and Grenzsinn. It has the tolerability of the compression of the right to religious freedom in relation to the interest pursued. As for the Italian context, in which the public exercise of religion is specifically recognized and guaranteed by Article 19 of the Constitution and is the subject of further specific protection under the Concordat, the only jurisdictional ruling that appears to have been made on the matter, a decree of April 2020 by the Regional Administrative Court of for Lazio, did not find that the measure of suspending religious ceremonies caused serious and irreparable damage, such as to justify the issue of a monocratic precautionary measure in adjudicated parte. This is because the sacrifice of that interest was temporarily compensated by the possibility of satisfying one's own religious feelings through the help provided by telematic and computerized instruments, i.e. streaming of religious ceremonies. A broadly similar assessment can be found in the rulings of the administrative courts of various German Länder and of the Bundesverfassungsgericht, which have generally held that the ban on celebrations open to the public was a proportionate measure in relation to the aim of protecting the right to life and physical integrity, and that, in particular, there was no violation of the right to free exercise of religion recognized and guaranteed by Article 4, Paragraph 2 of the Grundgesetz. It should be noted, however, that in a subsequent order of 29 April 2020, the Federal Constitutional Court came to a partially different conclusion with regard to the legislation of Lower Saxony, challenged by the local Islamic community, which established a total ban on gathering in places of worship. The Bundesverfassungsgericht stated in this context, in fact, that where a religious community is able to provide the health authority with the guarantees such as to exclude the risk of the spread of the virus, the measure is disproportionate in its absoluteness. On the contrary, the French Conseil d'État held in its decision number 440,366 of 18th May 2020 that the measure of suspending religious ceremonies was verbatim disproportionate to the objective of preserving public health, and that, therefore, given the essential nature of collective participation in worship, it constituted a serious and manifestly unlawful interference with religious freedom, as recognized by Article 10 of the Déclaration des droits de l'homme et du citoyen of 1798, Articles 1 and 25 of the Loi de Séparation of 1905, and Article 9 of European Convention for the Protection of Human Rights, which includes, among its essential components, the right to participate collectively, subject to the same reservation of public order, in ceremonies, in particular in places of worship. The French court's reasoning also includes considerations of reasonableness in the form of equal treatment, since it points out that the contested measure provided for less restrictive regimes for public access to various activities, some of which were also exposed to a greater risk than religious ceremonies, activities in which the judges note that the fundamental freedoms at stake are not the same. Finally, with regard to measures that merely limit the number of participation in religious ceremonies, the United States Supreme Court, after an initial deferential approach to what is considered a political question, such as the protection of health, in the case of the Diocese of Brooklyn versus Cuomo of 25th November 2020, even went so far as to find that such measures were not necessary, an assessment that was also linked to the finding of unequal treatment of places of worship, and stated that attendance at religious services was at the heart of the First Amendment's guarantee of religious freedom. So, while the assessment of necessity is undoubtedly related to the concrete factual situation that serves as the basis for the various measures, what ultimately emerges from the judgments analyzed is the different consideration given to the dimension of the public exercise of religion in the context of the regulation of the right to religious freedom. In this regard, while French and American judges expressly affirm the essential nature of collective participation in religious rights, the Italian and German judges are of a different opinion, who instead seem to see the hardcore of religious freedom in the possibility of satisfying one's own religious sentiment, to which collective participation in worship is merely instrumental. Given the possibility of satisfying one's own religious sentiment through other means, such as individual prayer, even in the place of worship or computer tools, the legitimacy of the suspension of religious ceremonies derives, therefore, also from the point of view of respect for adequacy. In conclusion, there are at least two profiles that, in our opinion, clearly emerge from the analysis carried out. The first is that, at least with reference to the current historical phase, the dimension of collective exercise of worship is not unequivocally considered to belong to the essential content of the right to religious freedom. That is, to what the regulation of this right cannot absolutely not include. And this circumstance seems to be not depending on the system of relations between states and religious denominations. Secondly, as far as the European context is concerned, the lack of standardizing role ordinarily played by the system of European Convention for the Protection of Human Rights and Fundamental Freedoms in the protection of fundamental rights must be noted. This is because Article 9 of Convention expressly admits that the freedom to manifest one's religion may be subject to limitations provided for by law, which constitute necessary measures in a democratic society for the protection of public health, thus constituting an explicit external limit to the faculty of public exercise of religion. Thank you for your attention.
Thank you, Dr. Dallon, also for complying with time limits. Now is the turn of the discussants. I've no guidelines about who would be the first. I don't know if Matej, Avbelj, Stefania, Ninatti, and Rapin who want to run first.
I think we should just follow the order of the program.
So Matej is the first.
Okay, thank you. Let me go first then. Let me first state extend my congratulations for this great event today. I do regret that I couldn't be in Trieste. It is not for the bad weather, even though I visited this month already twice and it was always bad weather, but that's Pietro's fault. But my fault today was that I couldn't come because I caught a cold, but I'm very happy to be here, even if just online. I was also very happy to have the chance to read these three very interesting papers, all of them still admittedly work in progress. And we were instructed that we in a way proceed in two steps, and I took the instructions to proceed in two steps. First, I'm going to draw some general impressions from the three papers together, and then I will make some really bona fide suggestions in terms of improvements of the papers that I had the chance to read. So the three papers taken together have exposed us to a very interesting, revealing comparative law exercise. For my own part, from the descriptions that I encountered in these papers, I had to say I learned a lot about the treatment of the freedom of religion in Italy, Sweden, and also in judicial terms, especially with regard to judicial terms, again in Italy, France, Germany, and the United States of America. And the lesson that one learns from these papers is that, and you and those among you who are comparativists know this very well, that even though that we tend to say as constitutionalists, or even those who work especially in the field of international law, that human rights are universal, and that in particular the freedom of religion, freedom of conscience is a universal human right, it is clear from these case studies that a universal human right can have very different emphasis in particular contexts. So as it was stressed and as it follows from all the three papers, in particular with regard to the freedom of religion, it's clear that the context matters. The history matters, culture matters, the actual character of a polity matters, whether it's a more homogeneous or a more heterogeneous polity nowadays. But what also matters is a contemporary character of a political atmosphere in a given country. So all that matters, and it translates into how also the freedom of religion was affected in this distress that we encountered in terms of pandemics. Now, another lesson that I did learn, and I think this was a good lesson from these practical case studies, was that in neither of the countries described, the severe limitations to the freedom of religions were not conducted mala fide. So all the states that were under investigation here limited the freedom of religion in order to really pursue legitimate public interests, bona fide. They didn't use these limitations as a pretext to clamp down on particular religious communities in these countries. So this is the general impression, and now I will touch upon on the individual papers a little bit, starting first with Matteo's paper. So I think Matteo's paper provides a nice description of the Italian treatment of the freedom of religion in the distress during the pandemic, the way the paper could be improved and strengthened, especially for those of us who are outsiders to the Italian state, to the Italian political community, to the Italian constitutional treatment of the freedom of religion, is to provide a little bit more flesh on the bones at the very introduction, explaining how exactly different religious denominations are constitutionally treated in Italy. And this kind of a more analytic constitutional treatment could be then used as a point of departure to convey the narrative of the way the Catholic Church has been approached and other religious communities. So putting a little bit more flesh on the bones, especially at the beginning, to provide a better insight in the Italian constitutional treatment of the freedom of religion for those who are not insiders to the system. Giuseppina's paper, on the other hand, is extremely ambitious, but among the three, I would also argue the least developed so far. There a little bit more work would need to be done. Especially, I would invite you to dwell more on the very concepts that you are using. There are very important concepts at stake, such as as you mentioned, the special position of the, as it were, state church still in Sweden. Then the socio-political phenomenon of this social trust in Scandinavia, and then this branch of Scandinavian legal realism. I think this could, in order to strengthen the paper, this should be, in definitional terms, this should be invested much more in. And in a second step, once you will have provided the definitions of this phenomena, I think the really hard task, and this will make the paper really important, academic contribution, is to demonstrate convincingly how these different concepts actually link together in a specific context of affecting religious freedom during the time of COVID-19. It is also from your presentation here, it wasn't entirely clear how the socio-political phenomenon of social trust into the state is related to the specific branch of legal thinking, doctrine of legal realism in Scandinavia, and yet again how then this links to the regulation of the freedom of religion during the epidemic. So this is for your paper, very ambitious, and I think it's really promising. And finally, to Valerio's paper. This was the closest to my analytical constitutional law expertise. I like the paper a lot, but I also still think it should be strengthened in methodological terms. It should be explained why these particular jurisdictions were taken as a case study. Why are they similar? Why are they different? So what in the first place justifies this kind of a comparative exercise? And then I think two important questions ensue from your paper that should be stressed more. One really goes to the heart of the constitutional dilemma, that is, what is actually the minimum core of the right to the freedom of religion. And I think you should elaborate this even more, this distinction between certain jurisdictions treating the collective exercise of freedom of religion as the minimum core of the right that ought to be strictly protected, whereas other jurisdictions do not do that. Finally, the final question which is raised, and here I would have some disagreement with you, which refers to the standard of judicial review, especially on the level of the European Court of Human Rights. I'm not so sure that your semantic argument, nomotechnical argument, that since the European Convention of Human Rights explicitly provides for justified limitations to the freedom of religion, this allows you to come up with a conclusion that there is no minimum essence of the freedom of religion on the European level, and that even if there was, it couldn't be applied in those states which opt for more favorable treatment. Here, I think you have to be careful, because a more favorable treatment of one human right always translates into a less favorable treatment of another human right, which is in conflict with the first right. So I think that the very theoretical thinking in terms of rights, in terms of their maximum protection, that the states are allowed to go for the maximum protection, I think this is to a certain extent misconceived. Because a maximum protection of one right means a minimum protection of another right which is in conflict with that particular right. So so much so, probably I've used most of my time, or even more, I've even go beyond the schedule. I thank you for your attention, and fingers crossed, really good papers. I'm looking forward to their final versions.
Thank you, Professor Avbelj. And now the turn is to Professor Ninatti, who has the floor.
Thank you. First of all, I would like to thank the organizer. Thanks to the organizer for the kind invitation, and especially Pietro Faraguna. And I have to admit that I share the same feeling Pietro told us at the beginning of this conference, since I am a constitutional lawyer dealing with papers on law and religion. But I have to tell also, to witness the experience that we have in Milan, and here there are some colleagues from Milan, that in Milano-Bicocca and also in State University of Milano, we have a strong and fruitful cooperation between constitutional lawyers and ecclesiastic canon lawyers too. So I'm very happy to be here. And the second premise that I should do is that the time is running late, and I fear that some very important, relevant points were already highlighted this morning, that could be interesting to reflect upon this point a little bit more in the debate. So I will try to apply this perspective that we have already heard in the morning to the paper presented today. And so I chose, and I had an agreement with Pietro, just to make some questions regarding the papers. And I will cut my intervention in this way. First of all, let's take, for example, because the general proposition I have is that I have the impression that all these three papers question the difficult identification of the special status of religious freedom within a legal system, and the occasion of pandemic crisis shows this in a very powerful ways. So if we take, for example, the paper written by and just presented by Valerio Dallò, I wonder, and I ask also Dr. Dallò, reading the paper, isn't the observation made by the Italian judge, Tarlazio, according to which the need for physical participation in the religious services can be, even if only for a certain time, replaced by digital participation, an encroachment on judgments that pertain to the religious confession? Wouldn't it be more correct to say that there is a religious limitation due to an emergency, instead of embarking on a discourse on a complementarity of certain religious practices. A similar observation can be repeated for the ruling of the Oberverwaltungsgericht of 2020, mentioned in your paper. Well, I do not want to go into the merits of this up and down of the case law, but the remarks concerning the identification of the essential content, the Wesengehalt, as the previous colleague just mentioned, of religious freedom in court, whether they are addressed to the Lutheran pastor or to the Catholic Church, remain problematic or questionable. By the way, in this sense, it could be interesting to observe, again from Dallos's paper, how the Supreme Court, on the other hand, has expressly sustained the opposite thesis. I quote, "The remote viewing of religious services is not the same thing as the personal participation," etc. The question remains open. Can a judge answer these kind of questions? And moreover, okay, we learned about the dialogue during this morning and from the paper of Giannelli, dialogue or loyal collaboration. But in a court, we don't have this kind of operation. So can a judge answer this kind of problematic points? Although in a completely different guise, it seems to me that a very interesting article by Matteo Giannelli addresses a similar problem. The weak involvement of religious confession in the pandemic management of religious activities has certainly been problematic and cannot be said to have been recomposed over time with a restatement of the constitutional model based on agreements. On the contrary, the adoption of the protocols described in the article rather marks, as the authors say, the passage to a kind of administrative participation. Legal scholars recognize in this way a tendency to replace, to overcome, here there are colleagues more titolati than myself to answer this question, to replace the principle of bilateralism with a sort of principle of loyal collaboration, with all the pros and cons that this principle has and that the European Union lawyers and constitutional lawyers perfectly knows. More cons than pro, maybe. For sure, bilateralism has shown its limit. But I wonder, is a kind of administrative participation guided by the principle of loyal collaboration the right way to replace, implement bilateralism? And again, if we read some part of these protocols, let's imagine again for the Italians the protocol with the Catholic Church of May 2020, we remain, let's say, surprised by the amplitude of the details concerning the modalities in which the religious services must be carried out. Was it necessary to go into such detail about a religious practice in a protocol? Well, we know perfectly how it was written, the Catholic Church, the participation, and so on, and that this choice responded to a need to control an extraordinary condition such as the pandemic emergency. But then I wonder, can we imagine to use this method in a more general way? Has it already been done? Wouldn't it better, in a dream, to adopt a new general law on religious freedom and then maybe a single specific protocol time by time depending on the problem that could arise, instead of adopting this principle of loyal collaboration or together with it? I know that I'm touching on a very delicate issue, the law on the religious freedom in Italy, but on the comparative perspective, I leave the floor to the comparative professor. But it was very interesting. Still, I really am not able to say a comment on the Nordic countries. I really do not a lot. Thank you very much.
Thank you very much, Professor Ninatti. And now the floor is for Professor Pin.
Is it working? Can you hear me? Thank you so much. Thank you, Pietro, so much for having us. Such a warm environment. I don't know whether you agree with me. I was fascinated by the fact that Glasgow is so beautiful. There's so many monuments. In keeping with what Stefania and Ninatti just said, and since I'm the only thing between you and the food, I will keep the intervention very brief and just tossing some ideas. And since we are being postponing the time for debate for hours now, maybe I'll just give some minutes to it. So I'm going to feed the debate with some questions. So starting with Matteo. So I'm wondering whether bilateralism immunizes from judicial scrutiny, which is one reason for which I would go through cooperation with religions, because it would be tougher for them to argue that their rights have been infringed upon since they agree on a protocol. And on the same page, I would ask whether individuals can file complaints arguing that their rights have been violated once their religions have said no, that it's fine to have such a protocol. I think we are watching very interesting scenario. You see governments signing agreements, envisioning that they will have disputes with religions and therefore trying to preempt them from litigating by having them sign protocols. But this, of course, leaves a lot to argue about, the feasibility of individuals complaining that their rights have been still violated. And then I'm coming to Valerio. By reading your paper, I would just wonder whether US judges like proportionality. To my knowledge, they don't, except for a few exceptions. Maybe you want to make that distinction. And I will just emphasize one point. So sometimes, and it's not because I didn't like the paper, of course I liked all the papers, but I would just like to emphasize that we often debate about how governments went about limiting rights. But this also depends on what kind of constitutional texts they are relying upon. So if there's something you can't do, you won't go that way. So sometimes you see differences and different strategies because constitutional texts are different or constitutional settlements are different. And this is something I would like to emphasize, that sometimes you don't have weapons, so you don't go into into a certain direction. And still in keeping with what Stefania said before, I'm wondering whether the prevailing religious traditions of a country affect the way judges look at limitations on religious freedom. So, for instance, Christian denominations valuing personal practice may be more lenient towards limitations of collecting practice, and vice versa, depending on their mentality. And then I left Giuseppina as last because I think that your paper casts some light on very broad questions, and I'd like just to stop after asking these broad questions that are actually looming over me, not just over you only. You are depicting a civil society that takes care of itself, which is quite interesting. So instead of pitting religious freedom against other rights or other interests, you are talking about civil society that is taking care of that. And the church is taking care of that, as the church has always done in several European countries and elsewhere since they've been running the welfare system for centuries. So it's not always true, and maybe it's not even that true that we can easily pit religious freedom against other interests. because we are talking that traditions that have been taking care of other reasons for centuries now. So it's quite interesting. And so I wonder whether you would like to tap the idea of subsidiarity into that paper, because it might help you frame the paper. And on a broader level, and let me echo, I think, Javier Martinez-Torron, what we are watching here is a lot of litigation stemming from a framework that we normally build up that pits science against right. So we know what we need to do many things because science is telling us to do that, and we all agree with that. So on the one hand we have science, on the other hand we have rights. I don't know if you agree with me, but you can see that you have a lot of governmental protocols, you have a lot of governmental bodies and committees that advising governments how to deal with a pandemic based on scientific evidence. And on the other hand, you have people claiming their rights. And when it comes to religious freedom, it looks like we are again talking about reason on the one hand, faith on the other hand, which is a very long-standing debate. And of course, this is a philosophical question that I have no weapons with me to fight that war, but I think this is a very, very tough issue to deal with, and at least we should be aware of that. And we should be aware that we are watching a new phase of a debate that has been ongoing for centuries now. So I'll stop here. I'm hoping I give some hints to those who wrote the papers. Thanks so much again.
Thank you, Professor Pin. Thank you very much. And with the permission of the organizers, I would like to put forward some remarks. May I?
You need no permission, of course. I'm just like connecting you to the room because I cannot change the camera. In case you would like to open a Q&A later on, we have a microphone that can connect people in the room and people connected online, just for later on.
Okay, thank you very much. Actually, given my lack of competence, these remarks are very sketchy and there should be more appropriately termed as footnotes. Trying to make clear some border issues that have been addressed or either explicitly or explicitly during the panel. First remark, very general, and it's something that addresses most of literature, focusing on today's subject, this panel subject. We speak of health. Matej spoke of freedom of religions and universal right. Right to health is, of course, another universal right. But we should always be aware that there is a notion of public health via a notion of individual health, a notion of collective health as opposed to community, or can be opposed to community health. And not to mention that the very notion of health should be made clear when we speak of these clashes between fundamental rights. This is something that I think I inferred being present also in Professor Pin's reaction. Second remark, again addressing a notion that is crisscrossing literature and case law. The very distinction between essential and non-essential services and businesses might be taken as a kind of an insult by many. But it's not too speculative, I guess, to suggest that the terminology helps trigger legal actors' negative reaction. Are places of worship non-essential? Are they less essential than grocery store or laundromats, liquor stores, airlines, mining operations, funeral homes? If regulators around the world had not used provocative word of this kind and had spoken more specifically in terms of relevant numbers, perhaps courts and debates could find the question of freedom of religion more challenging than already it is. From the same perspective, that's to say, making the freedom of religion issue more challenging. Think of the distinction made by a per curiam ruling of the Sixth Circuit in 2020, Roberts v. Nice, speaking of the distinction between soul-sustaining and life-sustaining services. Or one can think of the distinction explicitly put forward by Professor Howe and implicitly embraced by Dr. Dalot between premise-oriented and activities-oriented restrictions. This is a fine and insightful position, but this stance, to be fairly sustained, depends on some difficult issues of fact, some difficult factual issues, which mere speculation cannot answer, and yet they are relevant from a constitutional law perspective. To know the risks associated with various buildings and institutions, we need indeed to answer several legal questions. Does it matter if people are together for 10 minutes or 30 or 60? How long? How much does it matter? How much does proximity matter? If people speak together or sing together, what are the actual incremental risks? What happens exactly in drugstores and grocery stores? And how does it compare to what happens in churches and synagogues? Again, this is calling for a scientific approach, echoed or better stressed by Professor Ping's remarks, and we cannot do without in addressing this kind of issues. Then, third remark is more specifically addressed to Dr. Dalot. I would never overlap European law lingo, including proportionality and reasonableness, on the US legal framework. The US legal framework debate and case law and literature speaks of liberty via equality, of strict scrutiny, of deference, judicial deference to state legislatures or federal legislatures, speaks of precedents, super precedents, and distinguishing techniques. So proportionality and reasonableness are not quite fitting the same in the US legal scenario as they do in Europe. Also because the United States scenario is much more complicated than what we have addressed so far. But time limits oblige me to go directly to my last remark, that is addressed specifically to Dr. Scala. First, I mean that this is again, I don't see my role, given the lack of competence, as a critique maker, but rather as a suggestion provider. Two footnotes on 3 footnotes on your intriguing paper. First, Scandinavian scholars, and not only legal scholars, have long been free riders on the idea of social trust in Scandinavia. But size matters always. And speak of social trust in a 10 million people country, as large as 1.5 the size of Italy is, I guess, easier, and this works for any single Scandinavian country. That's much easier than it usually is for other kind and size of countries. Second, second footnote, allow me to work out of my limited knowledge and competence. I'm not a constitutional lawyer, but I would be very careful in speaking of codifications in Sweden. The codification one can refer to in Sweden is the 1734 Sveriges Riksdag, forgive my pronunciation, which was, as any other Enlightenment codification, a sort of patchwork, including procedural law, criminal law. The only difference between the Sveriges Riksdag and, for instance, Allgemeines Landrecht für die preußischen Staaten is that it was much shorter, 1,300 articles, as compared to almost 3,000 of the preußischen Staaten, Allgemeines Landrecht. Third and last remark, I would be more, as I should say, careful in quoting comparative law literature concerning Scandinavian countries, Nordic legal models, or Sweden itself. One could take into consideration some of the mainstays of the literature, such as Oruchu and Nelson, Schlesinger, Reimann and Zimmermann, Handbook of Comparative Law, Patrick Glenn, Legal Tradition of the World, Matthias Sims, Comparative Law, and if doesn't look unseemly, the Cambridge Companion to Comparative Law, for which I was one of the two co-editors. So this could give a sort of new veneer, a new glamour to your comparative law references. I stop here also because we have not much time left, and I would open the floor to anyone who is willing to participate in the debate.
No, I mean, was a request. Okay. No problem. I'm trying. I will just try to use the other camera, but then this is working. Maybe. Vincenzo, no? I know. Okay, I thought it was. Yeah, maybe we just open the Q&A and then I don't know if I thought it was your request for questions. No. Okay.
If I may just make some quick comments. The first one with regard to Andrea Pin's remark about science and rights. So all this about science is perfectly reasonable, but in some countries, as mine, these advisory bodies of the government, their names were never published. The government repeatedly refused to make public the names of the experts, and many people started wondering, oh, if they have been lying to us about so many things, why should we believe them now when they claim they have a body of experts whose name they are not willing to reveal? And then there is also the issue of the open scientific debate. In many other countries, there was the official scientific version of what the pandemic is, the reasons, the appropriate solutions, and whoever, irrespective of whether they were scientists themselves, whoever dared to question the official version of the scientific solution against the pandemic, it was changing, by the way, over time. They were stigmatized as dissenters and people that, under the guise of the fake news and the importance to protect people, the public, from falsity disseminated through social networking, it has been an actual control of the truth. All that was contrary to our very democratic tradition of freedoms. And then the two quick comments about the Pierluigi Consorti. He made a reference to religion not being privileged, being granted equal treatment and not privileged. The problem is that sometimes when you mention the specificity of religion, sometimes when you try to make a specific treatment of religion, people take that as a sort of privilege, and that makes things sometimes confusing. For instance, the singing that was mentioned by Maximilian this morning, so much emphasis on the singing in churches, but apparently there is not a big concern about people going to football stadiums for football matches. And we all know that in the Inter versus Milan, everybody keeps perfectly silent, never shouting for the 90 minutes of the match. Or Roma versus the Lazio, people behave in exemplary mode. And why is that differential treatment? And a last comment about the laicità and laicity and all that makes perfect sense. But again, sometimes I think that we are subliminally buying a sort of identification between society, state, and then government. Then we use, for instance, public, the adjective public, is equivalent to a state-run activities or institution. They are not the same. Public refers to society, state refers to state-owned or state. It's not, this equivalence, I think, is very confusing and very much abused in the political arena. Thank you again for your patience.
Professor Faraguna. Professor Faraguna.
We couldn't hear you for a moment.
Okay, can you hear me now?
Yes.
May we please ask anyone who is willing to speak from the floor to make clear his name, her or his name, and her or his affiliation?
Yeah, I will help you now. There is Wojciech Borowski who's raising a question.
All right.
Yeah, I mean, you have to turn it on and then leave it on, because otherwise it takes 30 seconds to connect and then we have to leave it on. So when we pass it, so.
Okay, I think
now
that
it's working.
Yes. Okay, thank you so much. Actually, I wanted to ask a question to Professor Martinez Torron, and I was fairly disappointed that I could not do it straight after the first session. But now I'm starting to think that this may be the right moment after these, say, national perspectives that we just discussed. I'm totally with you on the on how the European Court of Human Rights has been confusing necessity and proportionality in recent times, and how it has really damaged the proportionality principle, paying lip service to proportionality while in fact being the eager helper of the member states in upholding many restrictions to religious freedom, which are at least questionable. But there's one thing that comes to my mind instantly as far as religious freedom in times of COVID-19 is concerned, and it has something to do with necessity changing over time. Because necessity may change over time, especially in such dynamic times. And at the same time, it can also change from one place to another in Europe. Because what happens to be necessary in terms of preventing the spread of COVID-19 in one place in Europe may not be necessary in another place of Europe, because countries differ, jurisdictions differ, the climate may be different, the social norms related to the so-called personal space, and so on. But this conclusion does not sit easily with the effect of res interpretata. Because technically, what is considered to be unconventional in one case with one member state should be, as a matter of principle, unconventional everywhere in Europe. And in this way, this res interpretata effect spills over the whole European legal space. My question to you is, how do you reckon, I'm sorry for sitting, well, showing my back to you all the time, and this is how I avoid spreading droplets all over the place. This is why I'm asking my question without standing up. How do you reconcile one with another? I mean, should we revisit the res interpretata effect in terms of assessing necessity of anti-COVID restrictions in times of pandemic, or should we, or should the European Court of Human Rights tailor its judgments as to make precise what the desirable effects of a particular judgment would be or should be? I don't know if I made myself clear. I hope I did.
No, take the microphone. Otherwise, it is difficult to follow from home.
I hate these things. I think I should. The question you make, Wojciech, is very important. I'm not feeling to provide an appropriate response, but I have the same doubt about what extent these interpretations provided by the European Court, they actually, in the specific realm of religious freedom, they actually follow a regular pattern, or they are just very often influenced by the political, I would say, the political preferences of the members of the chamber deciding the judgments. Because out of the COVID pandemic, when you go to the religious freedom decisions of the European Court, you very often have the concern that France, for instance, is never treated the same as other countries when it comes from the separation, the restrictions of the religious minorities, etc., etc. So but I think what the question you make about the particular circumstance of COVID, I should have to provide the proper response. You should have a more reflection about this. Thank you.
I don't know if there are other questions from the audience, because if not, I would suggest to our chair to leave the floor to the speakers.
Of course.
Okay, should we follow the same order? I mean, up to the chair of the panel to decide what order we follow.
Absolutely, it's easier. Thank you.
So, thanks for all the remarks to Professor Ninatti, Professor Pin. I will try to take them and improve the paper, especially for the non-Italian readers. To Professor Ninatti, is this kind of participation a right way to replace bilateralism? No, I don't think so. Maybe I emphasize it too much. I think it's a peculiar way of expressing conflict, the political conflict, a purely political conflict in a different model away from the natural one, away from also the parliament and the legislative power. It's time to let a new general law on religious freedom. This is another explosive topic, which I would like to know the answer. I think the question I can try to answer this question relating also on the conflict, on the political conflict, on the way, in which way it's possible to express this conflict. And this consideration, I think, led also to the question of Professor Pin about the limits of bilateralism and the effective transposition in their communities. I think there's a need to find some places, some political places in which discuss these topics, not only social, but I think political, and I try to refer to the parliament, to the parliamentary committee, who also in this experience, in these 2 years, are away from the political debate, also on the sources of law, especially. Thanks.
Dr. Scala.
So I really have to thank you for the brilliant comments because they give me the possibility to go a little bit into the analysis. So I will start with Professor Avbelj. Is there? Avbelj, yeah, I don't see him, but yeah. Yeah. Thank you. Yes, this bona fide approach is the approach. Yes, I mean for the case I'm studying, but it is also true that I will try to go a little bit further on this expression, social trust. And I was thinking that maybe I have to underline that the analysis is first of all toward citizens, to core, and then try to get this link with religious freedom. So I think that, yes, the comment is perfectly understandable from my point of view, and I will try to go a little bit on this. Regarding the comments from Professor Bussani, this matter of size, well, I'm not sure if there is a link between this approach that individuals have in Sweden, but in general, I could say in the Nordic countries, regarding the self-isolation and this self-understanding of non-binding recommendation and the size of a country. I mean, if as an individual decide to self-isolate, what is the link with the control from the state? So I have to go a little bit also on this. And of course, if we think about the state controlling the individuals, that is of course easier when we have a population of the kind of the Scandinavians. When it comes to the expression codification, well, maybe yes. You mentioned the lag, the Swedish lag of that time. Yes, maybe codification is not a good term. I will try to change it. Professor Ninatti, I'm sure you can also give me your suggestions maybe in another time, but I will for sure appreciate if you do that. And regarding subsidiarity, yes. I'm thinking on this new role of the Church of Sweden. Should we still talk about this link? I mean, can't we go on and have like a real separation on this? I think you're right. It's not possible. I mean, there is such an historical link and such a social welfare system regarding also this church, which is, of course, a sort of agency still of the state. So thank you for this.
Thank you very much. There will be, of course, room for discussion about what we just said, as everybody's, as anybody else in this panel. Now, the floor is to Dr. Dalot.
I thank you very much for your precious remarks, and in a particular way, Professor Avbelj, for his suggestion to analyze more the problematics concerning the hardcore, the minimum core of religious freedom. About the minimum core of religious freedom in the system of European Convention on Human Rights, I'm not a lot of reliance, because the formulation of the disposition of the Article 9 recalls is the same of the Article 18 of Universal Declaration of Human Rights of 1948. And that disposition, I know that was the formulation was the result of a compromise between the Occidental legal systems and the Soviet Union one, and in which religious freedom is considered as an individual aspect of personality. So I will, in my future research, investigate better this aspect, but I think that I will not confidence, reliance with to find in European Convention a minimum standard of protection of human rights that is more guarantees that what is assessed by national constitutions. About instead the consideration of temporarity of emergency measures, measures by Professor Ninatti, I think that the Lazio Regional Administrative Court have inserted this consideration temporarity exclusively for in the evaluation of the extreme gravity and urgency as the prerequisite for issuing the measures required. But I think that the assessment expressed by the court is indicative, because it had that freedom of worship was not compromised, thus indirectly expressing an assessment of its essential core. I thank you.
Thank you, Dr. Dalot. Now, Professor Faraguna, I don't see the floor, or so I don't know if there are questions or interventions from the floor. Nor I know whether there's some of the discussants want to add anything to the discussion we had so far.
I think that the ambition to launch prevails over all this.
So I thank everybody for this fascinating panel. I thank once more the organizers, and especially Professor Faraguna. I wish you an excellent lunch and excellent prosecution of the meeting. Thank you very, very much.
Thank you very much. Thank you very much for having led us in time. Just some logistical infos. So the lunch will be served inside, because outside it is really impossible to do that. I'm sorry for that. We will start at 3 sharp. I think that we have a strong general interest to keep the end time as it is in the program, and even I think we could, if we start at 3 sharp, we could even, if we dedicate, as we did in this panel, 1 hour and 30 to the panel, then I should, I mean, I think that we should dedicate at least 30 minutes to the conclusion of Marco Ventura, and I specify that his conclusive remarks are referred to the entire day. So he will talk in English first, then just like to address that to the audience, and then I mean he will take in consideration everything what we said. The last thing, I'm very sorry to specify that for the speakers and people invited, we have this tons of paperwork that we have to subject to you. So please take one moment during the day just to fill in these forms that are in your folder. So it makes everything much easier. Otherwise, I have to then pressure you per email, and then you have to scan the documents, and it's even a bigger disaster. Thank you very much, and see you at 3 sharp. Yes, because we will be just out of this door. So, I mean, if everything